This podcast provides general information about the law, not specific legal advice. The licensed attorneys speaking on this podcast cannot take the place of a competent private attorney who can provide proper legal advice only after hearing the specific facts of your case.
You're listening to Law and Caution, Protection Through Legal Education, brought to you by Legal Aid Center of Southern Nevada.
Hello, my name is Josh Lozano. I'm a law student at William S. Boyd School of Law, and I'm here today with two attorneys from the Consumer Rights Project at the Legal Aid Center of Southern Nevada. First, I'd like to introduce Ryan McConnell. He's a staff attorney currently focusing on landlord-tenant issues, and he enjoys walking his basset hound on his free time. How are you doing, Ryan?
Hey, good, Josh. That's very true.
All right, and then next we have Nick Haley. He is a consumer rights attorney focused on housing and eviction issues. He might be the most important reason the Golden Knights won the Stanley Cup, because whenever he didn't shave, they won. So he temporarily retired his razor to help ensure the victory. How are you doing, Nick?
Yes, hockey rituals are important.
Yes, they are. Today we are discussing habitability, what to do if your landlord is not repairing. First, we'll discuss what habitability is, the proper steps you must take, your rights as a tenant, what to do if you withheld rent without following these steps, and what to do if your landlord retaliates after you complain. There'll be a short break and a game show quizzing the attorneys in the middle. In the description of this episode, you will find links for all the resources we mentioned, such as signups for the free tenants' rights class held here at the Legal Aid Center of Southern Nevada every Friday from 11 a.m. to 1 p.m. You'll also find timestamps so you can jump around and skip to the topic that's most important to you. All right, so habitability. For those in the audience, they understand this episode's about my landlord just isn't doing what they're supposed to. They're not fixing what's broken. But what is habitability? If you two can explain it.
Ryan, do you want to start?
Yeah, I'll go ahead and start with that. So habitability is essentially, in so many words, it's what makes a property suitable to live in. And I was trying to say it without saying it's what makes a property habitable, but it's what makes it suitable to live in. So your general idea is everything is functioning, all the appliances are functioning, there's no holes in your wall, there's no toxic mold, you have air conditioning, and this goes into the essential and non-essential habitability issues, but you have air conditioning, heat, a working stove, an oven, everything that a reasonable person would expect to have when you're renting an apartment or a house.
And about habitability, so you touched on it a little bit for the audience. What's the difference between essential and non-essential? Why does that necessarily matter?
I would say essential services are a subset of habitability. They fall under habitability, but essential services are things you just can't live without for any length of time. We're talking about running water, hot water, air conditioning, heating, a locking front door, those things that you just can't live without for any length of time.
Okay, so as an example for the audience, would a leaking roof be considered essential, non-essential?
Most likely that would be non-essential. That would affect the enjoyment of the house. Potentially over time it would create mold issues, potentially. It isn't something where you wouldn't be able to live in the house. This is late June in Las Vegas right now. We've been fortunate so far, but we're about to come into 100-degree weather. Air conditioning is an essential issue. You don't have that, you could be at risk. During the winter, heating. If you don't have running water, you can't bathe, you can't cook, you can't drink water. These are essential things. Something that's simply making the home less enjoyable to live in is more likely to be a habitability issue. If a leak's bad enough, potentially it would create, perhaps a big hole in the roof, which could lead to something that might lean toward becoming an essential services issue eventually. But most likely that's going to be a habitability issue.
Yeah, that's where I was going to go with it too. Is like if it gets bad enough and there's just a hole in your roof, then you could very well argue that that's an essential service. That I literally need a roof over my head, and there is no roof over my head.
When I got the place, I didn't think it was going to have a skyline.
Right? Yeah. A skylight without glass, right?
Yeah. So that's perfect. So for the audience, if you have an issue and you believe your landlord, it's something that they need to fix, you need to decide whether it's essential, non-essential. You can actually look this up. To make it a lot easier, you can just click on the link below to the Civil Law Help Center. They actually have a list of it. But all right, so what do I do if I go to my landlord and I mention this, and the first thing they say is like, well, that's what you have renter's insurance for?
Well, to start, when you say go to your landlord, it's important to discuss how you go to your landlord. If you have a habitability issue, it's fine to call your landlord. I would, however, recommend that you document your contact with them should things go wrong later. If this becomes an issue for the courts, you're going to want some sort of paper trail to show that you did reach out to your landlord, to show what you discussed with your landlord. Otherwise, it's possible that nothing will come of it if you don't document. You need to follow some steps to show that you've not only reached your landlord, but to show what you discussed with your landlord. You know, you can send an email, you can send a letter. Some people have sent text messages. The statute refers oftentimes to, mailing a letter, but I have found in court that even emails and text messages can have merit in court. You just need some sort of trail to show what you actually said to your landlord.
Yeah, and that includes a lot of, especially corporate landlords now have these maintenance portals or all-encompassing portals that you pay your rent through. Your lease is attached there. You're able to make maintenance requests or other requests there. And so if that's the way the landlord has it set up for you to make these types of requests, do it through the portal. You'll oftentimes get some kind of email confirmation, and that'll leave the paper trail that Nick's referring to.
All right, so quick summary for those at home. Our two attorneys always advise, make sure to have a paper trail when you go to the court so it's not what you say versus the landlord. Like Nick was saying, you can use text. Ryan was saying if there's a portal, make sure to use that. Let's just say that for the sake of this example, we brought it up to the landlord. Now, how long does the landlord have after being notified, proper notice, do they have to fix this issue?
There are statutory periods. To some extent, you do follow the statutory periods. It's 14 days, 14 calendar days for a habitability issue. For an essential services issue, AC, heating, running water, it's 48 hours after you've provided written notice. There is a practical element to it, though. There are some types of issues. For example, mold. You're probably not going to be able to resolve a mold issue within 2 weeks. So there is going to be a practical component to this where you have to consider, are they taking steps to fix the issue?
Yeah, the landlord needs to make a good faith effort in trying to respond to it. And we've seen this not only with mold issues, but with some essential services such as AC or heat, where especially in those really hot summer months or the winter months when it gets cold and a furnace breaks down, then getting an HVAC repairman out to fix the AC or the furnace, even if the landlord's doing their best to get someone out there, it may take more than those couple days. So what's the landlord doing in the meantime? Are they keeping you updated? Are they providing you with some type of temporary fix, some portable air conditioning unit to keep you cool, or some portable heater? Are they allowing you to go out and get those types of services and say, yeah, just go out and buy a portable AC, we'll deduct it from your rent, no problem. As long as they're working in good faith with the tenant and keeping them up to date, even if it takes a little longer, the practical element that Nick was talking about really holds up, because if an AC isn't available, it's not available. I went through this. I'm actually a landlord of a private property up in Reno, Nevada. And I remember I did an interview with a news channel down here about air conditioning issues. And then the very next day, my tenant up in Reno called me and said, the air conditioning's out. And we went through this whole process of, okay, well, let's get the guy out there. We got the guy out there. They made a fix. The fix didn't hold. And so my tenant calls me again. And it ended up that the AC unit needed to be replaced. And there was just no practical way to get that AC unit in within those 48, 72 hours it's 48 hours that are required. But to meet that statute, there was just no way it was going to happen. So we had to make arrangements with the tenant. Luckily, they were able to get a swamp cooler in there to keep them cool. We deducted an amount from their rent once everything was said and done, and we were able to get it fixed. But so as long as a landlord, not holding myself out to be the perfect landlord, but as long as a landlord is taking those proper steps to resolve the problem, they'll be upholding the statute.
Something I want to underline that Ryan mentioned, communication is a big part of it. You should give your landlord updates as to whether or not the fix worked. Conversely, the landlord should give updates as to what he or she is doing. Communication throughout the process is really important.
Okay, so 48 hours for essential, 14 days non-essential. However, that's not necessarily the time the landlord must fix it. It's the amount of time that they must make a good faith effort towards the fix. So just keep that in mind. All right, so notified the landlord. You talked to him. You properly notified him to stress what Nick was saying. You didn't just communicate it verbally. It's either been the 48 hours has passed or the 14 days, depending if it was essential, non-essential, and they just haven't gotten back to you or they haven't done anything. So what type of rights do you have as a tenant? What can you do to enforce these rights?
There are some timelines that are important. If it's something essential, your AC is out in the summer, your heat's out in the winter, you need to act quickly. Not just for the comfort of your family, but because some of your rights come up very, very quickly. The statute gives 5 days for an expedited relief of an essential services issue. 5 days goes very quickly. So if your AC goes out on a Monday, you're on the clock. You notify your landlord immediately, do it in writing. You know, it's fine to call, but follow up with something in writing. But if you want expedited relief and you fear that it's not going to be fixed quickly enough, you have 5 days to file in the court system to get expedited relief. So that's one of those deadlines that comes up very quickly that I want to flag. If it takes longer than that, there are a number of remedies that can come up, and it just depends upon what the issue is, and we can break down. There's essentially 4 ways you can address things in statute that we can break down one at a time.
Yeah, I'll echo what Nick said there, and I think that so the first remedy in either case is you can withhold rent. Importantly, this works much better if you're not behind in rent. In fact, if it's a habitability issue and you're already behind in rent, the court's not going to consider you withholding rent as valid because you were already behind. There's really nothing to withhold because you already owe something. But if you are up to date on rent, you can withhold your rent. That for habitability issues, that seems to work a little bit better because of the longer timeline. If it's a straight habitability issue instead of essential services issue, if the landlord isn't kind in terms of what you're trying to get them to do, and they say, well, you're withholding rent, we're going to try to evict you, then what you can do once you have an eviction case is deposit that rent with the court. And in fact, if you're going to win in that eviction hearing, you need to deposit that rent with the court. That's not a requirement for an essential service, but you do just need to put that money away somewhere just to make sure that if the time comes where you're ordered to pay that money or the landlord fixes the issue right away, that you are able to pay that money back.
Okay, and then so just to make it clear, if it was a non-essential issue and you wanted to withhold rent, you would still have to deposit with the court?
Correct, yeah.
But if it's an essential issue and you wanted to withhold rent, you wouldn't have to deposit it with the court?
Correct.
Okay.
But you should hold on to the rent anyway.
Right.
And then for those listening, if you missed it, it's very important. You couldn't use the argument of withholding rent if you're behind on rent.
Right. Nothing to withhold if you're already behind.
Yeah. All right. So Ryan and Nick were explaining one of your remedies. Let's continue with the rest of them.
Well, the second remedy would be mitigation. That's a fancy way of saying you fix the issue yourself, or you try to make the issue less severe. The easy example, air conditioning, you can get a portable unit. Potentially you could buy a portable AC unit or a portable, a space heater, and you could deduct the cost of that from your rent. Potentially you could ask your landlord, hey, I had to buy this because I'm still without heating or cooling. Here's the receipt from Walmart or wherever I bought it, and I've been using this the last few days because it's just too cold in here. And so you could potentially deduct that from rent. If it's an issue that's really bad, like it's 110 degrees and you just can't be in there at all, you might be in a motel for a stretch of time, in which case you'd save the receipt from that until such time as they were able to fix that.
Yeah, so make sure to save a receipt. It would be extremely difficult to try and prove, like, I bought this indoor AC unit from the guy across the street. We just exchanged cash. Make sure to keep receipts.
You always have to think down the road of, is this going to turn into a dispute? I don't think most people think in terms of lawsuits necessarily, but you do have to think down the road, even without a lawsuit, even if you're just going to the landlord and making a claim, directly face to face, you're going to have to say, I have this receipt, here's how much it cost, here's my proof.
Yeah, so you might get an incredible deal from Uncle Billy, but it would be very hard to prove that in the future. So just go to the store and get that nice receipt or order it online.
Absolutely.
And of course, depending upon what the issue is, mitigation or remedying the issue could be any number of things. You could be using mold killer to clean the mold that's building up in your wash area where mold's building up. It could be you patch the wall yourself because there's a breeze coming through it. Whatever it may be, you want to keep the receipts.
Absolutely. I guess moving on to the next remedy that we could talk about is breaking the lease. If you have a habitability issue, the landlord's not taking any efforts. You've sent that letter that says, hey, within 14 days, you need to at least make good faith efforts to get this fixed. The landlord isn't doing so, or they're saying they're going to, they're dragging it out. What you can do is you can break the lease after those 14 days. The statute says that you're able to do so without any of the penalties that may or may not be in the lease. So if the lease says, oh, you have a lease break fee of $2,000, you wouldn't need to pay that. You're due all your deposit back. And you really don't need to give any kind of 30-day notice at that point either. So if you send a 14-day letter or whatever notification you initially sent that says, hey, you need to fix this, or this is what I'm going to do, and you end up breaking the lease at the end of it, I always recommend sending another letter or another email saying, on May 15th, I sent you this letter about my what have you, the hole in my roof. And you have since made no efforts to fix this. So therefore on June 15th, I am moving out of the property. This is where you can send my security deposit, and that's that. And then you move on. Of course, that's always easier said than done. Because if you're in the situation where you're facing some kind of habitability issues and that's going to cause a lot of stress in your life in general, it's certainly not going to be easy for you to just pick up and find another place to live and pack up all your things. And so it's easier said than done, but that is always an option when your habitability issue that the landlord's not fixed.
On the back end of that too, if you're like most tenants, you have deposits, you have potentially last month's rent that you want to reclaim, and that leads into our fourth remedy, which is you can sue for damages. And potentially that's what's going to happen if you do attempt to end the lease early. I would almost avoid saying break the lease, because if the landlord's not providing you a habitable place to live, to me, they're breaking the lease. It's their breach of the lease. If it comes to that and you're moving out, the landlord might not be amenable to giving you back your deposits, in which case you might have to go to court for that. And depending upon the amount, you could either go to small claims court, or if it's an amount greater than $10,000, you might be looking at a more complicated issue. You could also potentially sue for other damages if your family was injured by the conditions in the home, either through some kind of medical issue or some injury. If the property wasn't properly maintained and you got hurt, potentially you could even be looking at some type of personal injury suit.
Absolutely. And that's a great point. You're not breaking the lease. I believe the terminology in the statute is terminating the lease. So you're terminating the lease agreement between you and the landlord.
Yeah. So for those in the audience, a very simple way is you're not breaking anything necessarily. It's just they're not providing what they promised.
I would say the important thing is just that people need to understand there is a process and you can't take shortcuts on it. You do want to document, you want to save your receipts, you want to communicate effectively with your landlord. You want to make sure they understand what the issue is. You have to put all of your ducks in a row. And if you aren't caught up on your rent before you make a habitability complaint, if you don't effectively communicate it to your landlord, if you don't have documentation, we say, create a paper trail, but, electronic, however you do it, but just have something you can show somebody later. It could effectively upend what you're doing. So it's important to do it properly.
Yeah, there's we've probably lost count of how many tenants we've seen, whether they're coming into our office or we've observed them in court, trying to use these habitability defenses to evictions. And because they either didn't communicate with the landlord about the issue properly, they may show the court pictures of just deplorable conditions in this property that the court will say, well, this is awful. But if they never notified the landlord about it, don't have documentation of it, did not deposit rent with the court for the habitability issue, that's a really big one, where if the court doesn't see that the rent is deposited with the court, regardless of the circumstances, the defense isn't going to win in that instance.
Yeah, and there's certainly a little leeway on certain issues. For example, it doesn't have to be paper, it can be electronic, and sometimes the amount of deposited rent can be in controversy, so sometimes the landlord might claim a different amount from what you do, but you do have to at least substantially try to comply with all those things. And just the documentation is really important. You have to approach this like you're going to have to come back 6 months later when you've forgotten all this stuff and present all of this in a way to show this is what it actually cost me.
So just remember, all those you listening, you might have an argument based on principle because your place might be horribly taken care of. But if you don't take the steps that these two attorneys brought up, then you won't have an argument legally. So make sure to document everything and give proper notice. And go to the Civil Law Help Center. There's going to be a link in the description that has all the steps on how to follow this with pre-made fillable documents like how to notify your landlord. And right now we'll take our break.
Navigating through court can be intimidating. The Civil Law Self-Help Center is here to help. Located in the Regional Justice Center in downtown Las Vegas, we're open Monday through Friday, 8 a.m. to 4 p.m., providing free legal forms, information on court rules and procedures, and community referrals. We can assist you with questions on small claims actions, landlord-tenant disputes, and protection orders. Remember, while we can't provide legal advice for your situation, we're able to provide legal information. Our mission is to increase informed access to the legal system for everyone, regardless of income, assets, or citizenship.
All right, and we're back. Now we're going to do the Want the Truth segment, which is where we just shoot some statistics out at the attorneys, have them guess, and then they'll talk a little bit about it.
I think I'm entitled. You want answers. I want the truth. You can't handle the truth.
I feel comfortable using legal jargon in everyday life.
Your Honor, I'd like to ask for a recess.
No, the defense is wrong.
All right, so this is a study put on by UNLV, George Louis Bertrand. This came out in 2018. Basically, out of 520 contested cases, out of those 520, what percentage or how many tenants do you think had their issue resolved by their landlord?
If I were to speculate on this, which I have no idea what the number would be, I would probably presume it to be somewhere around a little over half.
That's about where I was going to say too, about 50%.
So it says when asked if their grievances were resolved, 332 tenants reported that they did not find a resolution.
Out of 520?
Yeah.
So a little
under half.
All right. So now we're going to go to, so what percentage of that do you think when they sent their very first letter had their issue resolved out of the group that said that they had their grievances resolved?
I would presume that to be a low number. I would expect that the first letter probably didn't elaborate on the issue sufficiently to resolve it.
My gut tells me the same thing, but I'm gonna flip it and say that because they ended up getting it resolved, that the first letter did it. So I'm going to say like 75%. I'm going to go high.
Oh, well, that's interesting. Nick, you are spot on. So out of the ones that say that they got their grievances resolved, 16% of them said that they were able to do it off the first letter. So like what Nick was saying, massive percent probably was not clear on the letter or they didn't send it properly. But if you do what these attorneys say, you might find yourself as part of that 16.
Well, once again, I'm too optimistic.
I think some issues are a little more complicated than can be easily summarized in one communication anyway. It typically involves a dialogue, and sometimes you got to send a technician out to see what actually is the issue with the system that failed, or sometimes you have to dig into walls to find out, do you have a leak? Does your neighbor have a leak? So I think that's natural that it would take more than one letter.
That was just to get you guys thinking, but now we'll continue with the rest of the show. So we'll pick up what if I withheld my rent without depositing with the court? Or what if I was behind on my rent and now I might be possibly facing eviction? What do you two have to say about that?
Potentially, you're upending your defense. Mm-hmm. You have to follow the steps. If you don't follow the steps, you're going to lose, at least in court. Maybe you resolve it a different way, but if you're going to use the court system, you have to follow the statute. If you are behind in rent when you begin this process, it's just not going to work in the courts. There are a lot of ways to resolve things without the courts. If you have a good relationship with your landlord, you should be talking to them early and often to try to find something that works for both of you. A lot of landlords don't want turnover. The home sits empty for months. If you're otherwise paying regularly, they probably just want their rent, to where if they can resolve something fairly easily and keep you in there and not have to find a replacement for you, they want to do that. So if you have a good relationship with your landlord, it's probably best just hash something out before it even gets to that stage. If you don't, and you have to think more defensively, you have to follow the process.
Yeah, and if you're just unable to follow the process and you're not able to work with your landlord like Nick's suggesting, which happens in a lot of cases as well, you really just want to focus on taking the least bad option. So in a lot of instances, you're living in a place that's uninhabitable, you don't like the conditions, you're facing an eviction, and your defense is weak or non-existent because either you were behind on rent or you didn't deposit it with the court or for some other reason. Well, you still have the option of moving out of the property before the eviction hearing. And as long as you're out of the property before then, there's nothing for the court to adjudicate, because in Nevada, at least, the summary eviction process is only about possession of the property. So as long as you're out of the property, you get away from that situation that you're in, regardless of whatever habitability issue it is, and you avoid an eviction on your record. So while that's not going to be the ultimate solution that you would have wanted, that sure, the landlord is going to be in the wrong with this. They didn't do their job, but because you didn't follow that process, it's going to impact you negatively anyways. So a lot of times we do have to counsel tenants to take that least bad situation, and if they're absolutely able to, move out of the property before any kind of court hearing.
To the extent possible, I like to give people just a practical view of their circumstances. Oftentimes, you're in housing that needs a lot of work. Maybe the landlord is cash poor. We often don't know what their situation is, but if a home is in bad shape, it might be possible that the landlord needs to do a lot of renovation, and that might involve you finding another place to live because the property is just that much of a mess, and it's just not practical for them to do what needs to be done to make it a habitable place to live. Depending upon the circumstances, a habitability issue can go any number of ways. The example of a cash poor landlord is more common than people realize. Oftentimes, home's inherited by somebody, or it's somebody who's had the home a long time and has used it as passive income in their retirement. They might not be in a situation to do what they need to do. They might not be suitable to be landlords, and the issue you present to them just makes that clear. And in those circumstances, just understanding where they come to the issue points in the direction of where you need to go yourself. Oftentimes they're just not going to be able to resolve the issue, and maybe breaking the lease is the option, or terminating the lease. it's important to understand what you want to see happen versus what is practical to see happen.
Yeah, and then for those of you that are going to heed the advice of, maybe I should try and leave early before the eviction, make sure that you can prove and argue that you actually did move out. It would be hard to prove that if all your stuff is still there and you tell the court, yes, I did move out. All your beds are there. Your dog is there. So make sure. And this would be a great opportunity to consult an attorney, check out any of the free classes and resources. Is there anything else you two would want to add for the audience?
You made a great point there, Josh. Simply not physically being there doesn't mean you moved out. You got to say something. You got to say, I'm not coming back. Here's the key. You can dispose of what's left in there. I'm not coming back. That is an important point to make. So I'm glad you brought that up.
Yeah. And of course, get your pets out of there. Definitely get your pets out of there. Please don't leave the pets behind. But even if you don't have all of your belongings out of there, what Nick stated, where if you have an eviction hearing, you're in open court, you weren't able to physically move all your belongings out beforehand. Most of the time, if you hand over the keys in open court, the landlord needs to provide you 30 days to get your personal belongings out of the property anyways after you move, after you're evicted or after you return the property. So you can turn over the keys and still work out some agreement with the landlord to, hey, I'm going to come with a truck on Tuesday to get the rest of my things. The landlord also has to, within the 5 days of the tenant turning over the property, they have to let the tenant back in to get their essential items. So that's medications, baby formula, anything that you absolutely cannot live without. The landlord needs to let you back in for that. So you can return the keys and then still go back and get your belongings after the fact in order to avoid an eviction. But get your pets out, please.
Yes, please.
Get your pets out. Make sure to heed the advice and warnings of these attorneys. Thank you for listening. And if your landlord ever retaliates because of one of these things, you complain and they lock you out of your own home, but you're up to your rent, there's also steps on the Self-Help Center on what you can do, which we'll probably do another episode about landlord retaliation.
Thank you for listening to Law and Caution, Protection Through Legal Education. Links to helpful resources can be found in the description. Have a great day.